Rebecca Roiphe joins me now. She is a CBSN legal contributor and former assistant district attorney in the New York County DA's office. Rebecca, welcome. So we heard today 3 of the scholars called by lawmakers, 3 called by Democrats, argue that, yes, there is enough evidence that what President Trump has done constitutes an abuse of his power, an impeachable offense. We then heard the 4th constitutional law expert, Jonathan Turley, who was called by the Republicans, say, wait a second, I don't see enough evidence here. This is going too quickly, right? So he didn't necessarily say, no, the president did not, did not do anything that is impeachable. We just haven't yet seen enough evidence. We need to have witnesses that were subpoenaed. We need to hear from them, right? Was that his general argument?
And so, I mean, I think it's really what he didn't say that's actually more interesting than what he did say, which is he didn't say if there were direct evidence of a quid pro quo, which obviously the House Intelligence Committee believes that there was, and he does not. But if there was, I think he would agree that that would be an impeachable offense. He's written as much in public, in the public, so he would definitely agree to that. The thing is that he doesn't think that there is enough evidence yet.
Was he ever asked that question point blank? If there were witnesses who could say yes, they heard the president. Well, he was not asked that question.
He was quoted his language in that Hill article, and and people said, "Do you still agree with that?" And he said, "Yes." So he has said that,
right? But the Republicans are basically basing their argument on him, at least from today's hearing. Do you think that he made a strong enough argument for the point that they are making, which is that the president has not done anything that constitutes an impeachable offense?
I mean, I think the best thing he did for their argument was to parrot their view of the facts, which is the facts as they've been laid out so far are insufficient to support this quid pro quo that would amount to bribery that would be an impeachable offense.
Right.
And again, I don't know why this law professor is considered an expert on the facts. He's an expert on the law. He's not any better than you and me at determining what these witnesses have established or not. I mean, that's for the American public and for the House as a whole.
Right. And as we talked about earlier, bribery may not be one of the articles of impeachment. It's looking more and more like abuse of power. Is that right?
Well, yes. And that was one of his disagreements as well. So he was saying, I don't think that a president should ever be impeached for something that is not a crime. And when he says crime, he means a federal criminal statute covers the conduct. And it's interesting. I just want to point out this irony, because normally the Republicans who have supported justices who are originalists focus very much on the original meaning of the Constitution. Here, he's saying something slightly different from that. And Representative Collins was kind of laughing and saying, like, we can never get into the minds of the founders, which is sort of a typical liberal view. Right. So it's kind of like things got all reversed in that particular way. But yeah, he was saying it needs to be a crime under the bribery statute in order to constitute an impeachable offense.
You know, I want to play something that Republican Congressman Ken Buck of Colorado asked Professor Turley. He pressed him on whether actions of past presidents might have been impeachable. Let's listen.
In fact, let me ask you something, Professor Turley. Can you name a single president in the history of the United States, save President Harrison, who died 32 days after his inauguration, that would not have met the standard of impeachment for our friends here?
I would hope to God James Madison would escape. Otherwise, a lifetime of academic work would be shredded. Once again, I can't exclude many of these acts.
So do Republicans have a strong argument there? I mean, I guess the point that Ben Buck was trying to make is that politics is politics. It's kind of a dirty business. Everyone engages in politics, and there's a lot of gray area there.
This, to me, is the best Republican argument that there is, which is, yes, of course, the president was somewhat in it for his own personal gain, but presidents are always engaging in foreign policy and domestic policy with an eye toward political advancement. So this is no big deal. It's kind of like what all of these presidents, including presidents that, most people think of as, these huge iconic figures, have done in the past. And so to me, that's the best argument. And it's sort of a distraction to me to say the president wasn't trying to do this. It just, after all this evidence, it looks so clearly like he was. There was no valid foreign policy reason to ask a foreign country, one that the Republicans themselves said is basically corrupt, to investigate a U.S. citizen. That is not in the national interest. So that's not what was going on. But you can say, shrug, it's really not that big a deal, guys. Get over it.
That's
Kind of
what
like
Mick
in
Mulvaney's
Mick Mulvaney.
saying.
But that's
Yeah.
what he was saying.
Yeah.
And Ken Buck's line of questioning was really good in establishing that, which is just to say, this is the way things are done. This is the way they have been done, and they will be done. If you set this precedent, we will be able to impeach any president.
He went
That's
through
a good argument.
a litany of bad behavior by previous presidents.
Right, including FDR, Lincoln. I mean, he
And
went through,
Professor Turley did not say, no, those weren't impeachable offenses to each of those particular instances of bad behavior that Ben Buck brought
under the
up.
standard that the Democrats, or at least
Right.
these experts, were trying to suggest. Now, they came back, the experts on the side that the Democrats had called, and came back and said, if you could establish those facts, then I do think that would be an impeachable offense. So they weren't cornered by this, but I thought that was effective.
So in comparison, which did you think were some of the stronger moments for the Democrats camp?
I mean, I really think the strongest moments for them were the opening statements of the three law professors who were very succinct and very clear about our constitutional order, and kind of going back to first principles and establishing America. Why do we care about American values, and what are American values? And they laid that out very well. And that's been a problem, I think, up until now, with moments of clarity. But it's like, why are we doing this? Why do we care? The people who are saying this is a distraction or it's taking away from, Congress's real business, you need to refocus and say, no, this is important. And I think they did a really good job of that.
What I think is interesting about Professor Turley's argument that, the Democrats need to take a little bit more time here, and they have to make sure that these witnesses testify, which means waiting for these subpoenas to inch their way through the courts, is there is a timeline here. It's the 2020 election, right? And you can either say Democrats don't want to be accused of affecting it by having this drag out too close to the 2020 election. But you can also say that if it is the case that the president is trying to manipulate things in his favor illegally, then you also don't want to give him the leeway to continue to do that right up to the election.
Right. And there's another point, too, which is there is something categorically different, I think, about what President Trump is doing as opposed to previous presidents. So the idea that nobody can come, that he has issued this blanket letter through his White House counsel saying, we are not cooperating at all. No one can come testify about anything. No other president has ever done that. Now, of course, they've contested. They've said this is covered by the executive privilege. This isn't. You can't ask this line of questioning, but you can ask this. That categorical refusal, I think, is different and could support an obstruction of Congress count more than just run-of-the-mill, I'm asserting the executive privilege, which, of course, any president has a right to do.
Rebecca Roiphe, thank you for sharing your legal expertise with us.
My pleasure.